are we getting that money back?
Your mic. Oh.
Sorry.
Is it on? Yes. No. The payment, the increase in the payment of TIF funds by the CRA to Miami-Dade County at this point is completely independent of and not dependent on and not based on anything that happens with baseball. Baseball now has a life of its own. We have a independent, freestanding obligation as expressed in the amendment to the interlocal to make that payment for a purpose that is authorized under state law. We're paying to help out the PAC, which is the catalytic project in the Omni-CRA area. Baseball or no baseball, the payment now exists independently. The language that you refer to in the global agreement is just purely a gratuitous kind of expression of intent at the time that the parties were negotiating for something. But now the obligations have been memorialized in independent contracts.
So they're going to keep the money?
Yes.
And we are going to keep sending them up to $25 million a year to defuse the bonds, regardless of if there is a stadium or if there is a tunnel. Is that correct?
That is a correct interpretation of what the parties have memorialized in subsequent contracts.
Thank you, Commissioner Regalado. Commissioner Sarnoff, Sanchez, you have any comments in closing? You have Commissioner Sarnoff?
I'm just trying to think. So it is the city attorney's position that it was the mere execution of the baseball agreement that triggered the additional TIF money.
That is plain and unambiguously the way that it has been expressed in the agreement.
And all amendments to the agreement are in place, whether it was the 96 or 97 interlocal agreement, they've all been amended as a result of our action taken in December of 07?
The CRA interlocal agreement between the city, the county, and the district has only been amended once, and that is the December 13th amendment, the first amendment. There are other separate, the redevelopment plan is a whole different set of documents that were adopted.
But what you're saying is all legal impediments towards payment have been cleared, and now there's a legal obligation to pay.
Correct. All conditions subsequent that were expressed in the December 13th agreement have been met.
All conditions preceding to payment.
Well, they're expressed in the agreement as a condition subsequent, because it was a condition subsequent to the interlocal agreement that has been commonly referred to as the global agreement.
Can you see the agreement? Do you have it there?
You have a copy of the agreement?
I have it in the back. I can get it for you.
But you're saying, Madam City, I don't care if you, I'll talk, you're saying it's a condition subsequent that we're paying upon?
Madam City Attorney Gail, okay.
Commissioner Sarnoff, we will wait until we get the agreement in terms of to tell you what it says specifically.
While they're looking up that, do you have any other things you want to add, Commissioner Sarnoff or Sanchez?
Well,
I don't know how long it's going to take.
No, it's going to be very brief. I'm a bit concerned. This is a binding agreement. All conditions have been met.
Okay, it's paragraph 10 of the agreement that has been commonly known as the global agreement, and it says conditions subsequent. The county, the city, and the Florida Marlins agree that the funding commitments to the PAC as set forth in this agreement and in the first amendment to the Omni-CRA interlocal and the new Orange Bowl as contemplated herein shall be void unless a binding agreement for the baseball project is executed containing the following provisions, and then it lists 4 provisions. The agreement has been executed. Whether or not those provisions that are listed in the agreement come to a fruition, whether we agree to the management agreement, whether there's no more than 6,000 parking sites, all those things, it doesn't matter whether they come true or not. What mattered was that the baseball agreement was executed.
Well, that's why I asked you the question whether it was a condition preceding or just a condition subsequent. Because you've kind of, I think, just...
Well, the agreement calls it a condition subsequent. That's how it's called in the agreement.
Did you see it?
You don't believe me, do you?
Well, I think it's a big distinction.
It's requested by the parties.
Here.
But I thought the interlocal agreement was a local act, and the redevelopment was a statewide state statute that governs the redevelopment agencies throughout the state of Florida, which usually the state law, also federal law and state law, overpowers the local act. So that's why I was asking whether or not the redevelopment plan, which is what the state mandates, needed to be revised, because the interlocal is just a local act, has never been approved by the state, and the state statute is what governs the redevelopment agencies. That was my question.
Where does it set forth in the agreement the exact amount? The attachment.
It goes from 1.4 million fixed rate to a new rate that stands at 5.3 million. That's the language on the agreement.
Commissioner Sanchez, do you have anything you want to add while he's looking that up?
Once again, I want to just put on the record that our attorney tells us, and after reviewing, it is a binding agreement. And I'm very concerned with the message that we're sending, that we are breaking binding agreements.